Viewers, welcome back to the Personal Injury Law Show. Before the break, we we're talking about cyclists and horses and that sort of business. And Rob, are you going to give us the facts of this case of McLean and Meach?
Yeah, this is actually pretty straightforward on the facts, Tony. Basically, what we had here was a horse that was registered on a property. Quite relevantly, this property was adjacent to a major highway. Somehow, this horse managed to escape from the property and wander out onto the road. One vehicle collided with the horse and then was knocked onto another vehicle, a second vehicle that it collided with as well, and the person in the second vehicle sustained quite significant injuries and then sued for those injuries.
Before I go to Don with what happened in court, what did it get out? Was it defective fencing?
They still don't know exactly what happened. Right. Somehow this horse got out, but there were suggestions that perhaps there was some sort of fault on the part of the owner of the property or the owner of the horse in maintaining the fences or keeping the horse on the property.
And Don, what did the court find?
Now, it went to a jury. So at first instance, the jury found that the occupier of the land was liable for 67% of the damages, and the horse owner was 33% liable for the damages.
But you know what's extraordinary about this one, Don and Rob? The occupier didn't even live on the property. So why would there be such an imbalance in terms of...
Well, the occupier, the court dealt with whether or not there's a special duty. So we all have a duty of care in these certain circumstances. The question is whether or not in these circumstances there was a non-delegable duty of care owed.
Which means?
Which means that you cannot delegate the duties to look after or to take reasonable care to prevent harm.
So the occupier, Rob, is not allowed to delegate it to the horse owner to ensure that the fences are safe.
That's right. They can't just pass on the responsibility and say, no, someone else is supposed to take care of that.
But in this case here, she wasn't even paying to adjust the horse, was she?
She was the daughter of the owner, and the owner was only interested in a winery. It's a winery, and there was some paddocks attached to the winery. So she didn't pay. She was a mere, what they called, licensee. So she just had a license which she didn't pay for to use that property to adjust her horses.
Sounds pretty harsh, doesn't it?
Well, it does, and look, it really goes, there's a non-delegable duty, so the owner, the occupier, cannot delegate those duties to look after the property, but at the same time the jury found that the licensee, the horse owner, was 33% at fault, which, if you've got a non-delegable duty, how can another party be at fault if you're responsible for it?
I think the big thing to come out of this, and this is for the viewers, if you've got property that is an empty block of land or a farm, and you allow someone else to put an animal on it, that is a horse, cow, goat, whatever, if they get out, you as the the owner of the land, is going to be responsible for the larger proportion or chunk of damages.
We should say that it's according to the facts. So in this case, they put a non-delegable or special duty on the occupier of the land because it was adjacent to a major highway. But if you've got a block of land that's in the middle of nowhere, and the risk is very small that even if the horse gets out, that an accident's occurred.
But I still think from this case, Rob, what I've gleaned from it is that if you don't have good fencing and you allow someone to put a horse or a cow or something else on it and someone gets injured...
That's right. If there's any foreseeable risk of something like that happening, it's best just to cover it and make sure everything's locked in and secure.
And realistically, it's problematic, isn't it?
Definitely, absolutely.
So every time you think, oh, Julie up the road's going to leave her 20-year-old horse on the block, just you better make sure the fences are in good order. Isn't that right?
That's right.
Because you will be responsible. Let's get on to the next case, because time does go pretty quick. Harmer and Hare. Who's going to give me the facts of this case?
I can give you those facts. So this one's a little more complicated. This case concerns Mr. Harmer, Mr. Hare, and another gentleman, all of whom had decided to do some burnouts in a car. So they went to Mr. Harmer's property to pick up his old car, which was he'd been doing works on to bring it up to roadworthy standard. When they got there...
Not doing burnouts, that is.
Well, exactly. But to bring it to a standard to bring it out on the roads. When they got there, they decided they'd put some new wheels on it, some wheels that they had that they'd bought just for the purpose of burnouts. Now, at that stage, they'd all been drinking. Mr. Harmer was by far the most drunk, so his friend Mr. Hare, offered to drive. Mr. Harmer handed over the keys, and they went to drive to this other property to pick up the wheels. Now, what Mr. Harmer, the owner of the vehicle, didn't tell Mr. Hare, the driver, was that the wheels on this car were already completely bald and had no treads on them. It had been raining that day, so when they went out on the road and Mr. Hare manoeuvred through a roundabout, the car aquaplaned and they crashed into a pole, and Mr. Hare actually sustained severe brain damage.
And what happened, Don?
Well, look, Mr. Hare won this case. They found that the owner of the vehicle owed a duty of care, and that is to have not allowed Mr. Hare to drive the vehicle. So having full knowledge...
Why did Mr. Hare drive it in the first place?
Because Mr. Harmer, the defendant, was very
Sick,
drunk,
Very heavily
Fall
intoxicated.
down drunk.
absolutely drunk, and he was insistent that he'll drive the vehicle, and Mr. Hare, doing the right thing, said, I'll drive it for you.
And the case was appealed.
That's correct, a couple of
Now, I
times.
should say this year was a built a case. This was first heard in 1999.
Shit.
Now, the first instance, he won, and he was awarded $1.7 million, but it was reduced by 25%, Tony.
For his contribution.
They thought he knew that the vehicle had bald tyres.
Okay.
But as it came out in Court of Appeal, the judge actually misunderstood the evidence that was given by the
Okay.
plaintiff. And in fact, the plaintiff said he wasn't aware, and the judge inferred that he was aware. So, there's a
So
bit
the
of that
case went to
dispute.
the Court of Appeal, then it was sent back to the same
Sent
judge
back,
again.
And then went back to the Court of Appeal,
So it went back the second time.
second time.
Why did it go back the second time? Rob, do you know? Or, well,
There was a continual issue as to the contributed negligence and whether or not the driver or the owner was liable in negligence for failing to prevent Mr. Hare driving the vehicle. So it's still around the same basis, but ultimately the end result was that the court found that the driver or the owner owed a duty of care to the plaintiff, and the duty of care should have been not even just a warning, it should have actually prevented him from driving the vehicle where there was full knowledge that those tyres were bald and an accident like this could occur.
but Rob started this case by saying that they were very good friends and they were working on a car together.
Well,
So how could Mr. Hare not know that the tyres were bald if he helped him put the tyres on in the first place?
The facts are a bit unclear because Mr. Hare actually had amnesia for a certain period of time. It seems he was aware that works were being carried out, but he didn't actually know anything about the tyres.
But didn't he help him to do the works?
Not that part.
No?
The facts didn't seem to indicate that he had any knowledge at all of the state of the tyres.
And what happened in the end? What did he get? What did...
Well, they upheld the $1.7 million verdict.
And reduced?
And none.
Oh, no reduction.
No reduction because the court found that it was not open to reduce it where he did not have knowledge of those bald tyres.
Geez, there's a lot of conjecture about knowledge, wasn't there?
There was, and I think the important thing about this case that's come out is that it's not sufficient for a driver knowing that the owner of the vehicle knowing that the vehicle is not safe to warn a person not to drive. So if my
Okay.
vehicle's not safe and I say don't drive, you're going to have this accident, you actually have to try and take a step
if
further.
I take your car, with your permission, you should say, careful, my brakes are a little bit dodgy, or the
maybe-
steering's not right.
Well, the court actually even suggested take the keys from you, not
Don't
let
have
you
to
drive.
get off the vehicle.
Okay. Anyway, very interesting, and we'll probably have to take it up another time. Viewers, don't go away, because after the break, we've got the mailbag. So please stay tuned, and thank you, guys.
Thanks, Tony.